you all for coming tonight. For those of you that don't know, my name is Dan Olka. I run a company called the Medtech Director, and we have an association called Medtech Council. I produce 4 medical conferences a year in Southern California. The next one is World Medtech Day on May 7th. I hope you're all going to be part of. It's the first international medical device show of its kind, where we're going to have Australia, Switzerland, Hong Kong, and other countries involved in it with an online format, and then it's going to come back to a live event here in Irvine. Our event tonight is being held at the Cal State Fullerton Incubator, and Philip Stennis, who runs the incubator, I'd like to have him come up and say a few words to us.
Thank you. All right, so welcome everyone here. I just wanted to say thank you for showing up, and for those of you who are in the startup world in terms of starting a business or happen to know someone starting a business, that's what we do here. We do mentoring for about 6 months for those people who are looking for the early stage guidance, and we help people avoid those costly mistakes. With that, I have some marketing materials up here, and you can see our process. I'm happy to talk to you independently about that, or someone that you know. So I will turn it over to Dan for the rest of the presentation.
Well, one thing we like to do at our events is have different talks, and I bring different experts in at some of these events, and we want to do something different for the college. So we brought 2 experts in, and one thing with my business where I'm lucky is I get to meet so many different people. And Rand has been someone that has spoken at my events in the past, and so has Austin. And Rand is a licensing expert who has licensed everything from kids' electronics to the most sophisticated medical devices out there. And Austin is a patent attorney who has his name on hundreds and hundreds of patents, and is a great IP lawyer. So without further ado, I'm going to have Austin come up and start, and go from there. But thank you all for coming again.
Thanks, Dan. So hi everyone, my name is Austin Bonderer. I'm a patent attorney. I've been a patent attorney for about a little over 20 years. I've been involved in patents for over 20 years. I was a patent examiner first, and now I'm a patent attorney. And as Dan mentioned, I have my name on over 600 US patents. So, first things first, disclaimer. This is important because it's legal. The following is presented for informational purposes only. Nothing contained herein should be considered legal advice nor considered to establish an attorney-client relationship. My experience as a patent examiner does not provide any official advantage in the procuring of patents. Please consult a patent professional. This stuff can be dangerous. It is, very. So just to keep it short today, we're going to have a question and answer session after this. So I just wanted to give a brief overview of the patent prosecution process. So there's basically 3 phases of patent prosecution, as I term it. There's the prior art search phase, which typically takes 2 weeks to 1 month. So what is the prior art search phase? It's basically when we go out and we try to determine if your idea is worthy of an invention. Now understand what I tell people all the time. You don't need a patent to make money. People make money selling forks and shirts. Lots of money selling shirts. But so in any case, when we do the prior art search phase, understand that any prior art, which is something that has been published anywhere in the world, can serve to prevent you from getting a patent. So typically when we do a prior art search, we only focus on the United States. And this is because of time and money. You can get a search worldwide, but it's going to cost you tens of thousands of dollars. So why is it worth getting a US patent search? Well, consider it like insurance. It covers a lot, but it doesn't cover everything. And the worst thing to do is pay a patent attorney a bunch of money to write your patent application just to find out that something that you could have found would have prevented all that cost. And as you can tell, prior art search phase is the shortest time frame of this process. And then next, we go to the application writing phase. This basically takes 1 to 2 months, depending on the back and forth. And this is basically you working with your patent attorney to make sure that your patent is everything that you want it to be, and then file it with the patent office. Now, as you can see, the prosecution phase. Do any of you ever, have y'all had a patent anywhere? How long did it take you from the time that you filed it to the time that someone actually looked at it?
Still waiting.
Still waiting, of course, yeah. It can take up to 2 to 3 to 4 years, depending upon the art unit that the application gets placed in. So during that time, after we file, we basically sit and wait. There is a way to shorten that phase, but of course, it costs more money for the government to pay for it. But sometimes it may be worth it, sometimes it may be not. Now understand that if the prosecution phase takes too long and it's not your fault, the patent office will extend the term of your patent. So not all is lost if it takes too long. And sometimes it can actually be better for you. Because say your product hits and your patent is worth a lot of money, the longer you get to assert it against everyone. So those are the 3 phases of patent prosecution. Hopefully at the end you get your patent and go on your merry way and try to get it licensed. That's all for me, and I will take your questions and
So now I'm going to take you through, as Austin said, what I'm going to focus on here is not so much the, let's see here, not so much the what is the licensing process, but really some 3 key areas that what I consider are the biggest mistakes. And so for those here, how many are familiar with the licensing process? Okay. How many have a lot of questions about the licensing process? Probably so. So, as I said, what we're going to do today is, as we talked about, the subject here, the do's and don'ts, is I want to bring to your attention what I consider 3 of the biggest mistakes or challenges that I see in the market, especially when it comes to licensing, successfully licensing your technology, and what you can do to avoid those mistakes. So just real quickly, a little background on myself. For those I haven't met, my business is on the licensing. I'm on the business development, the deal-making side. Austin is on the legal side. I'm on the deal-making side. What I do is work with clients, take their IP, figure out the strategy, the plan, how we're going to license it, who we're going to license it to, how we're going to do the outreach, what we're going to communicate to them, and then I go out and do the heavy lifting, a lot of business development and sales work that's reaching out to the companies. Believe it or not, many companies out there want your IP, they want to license it, but they have no formal intake process. Oftentimes, a lot of my business is simply going through a lot of contacts inside these companies to figure out who the right person is. And I can talk about more of that later on. So I work with a variety of different types of IP. As Dan said, I do a lot of work in the medical device and medical technology space, oral health care, surgical devices, orthopedic devices. It really runs the gamut. A lot of interesting IP out there. So the first issue that I see a lot that most people run into, I would say, is no market validation. Most important thing you have to understand is that when you present an IP to a company, they want to know, first of all, does it work and will somebody buy it? If you have just a rough prototype or a concept and a lot of unanswered questions, it makes it very difficult for these companies to consider it. What are they looking for? What they're looking for are innovation, and intellectual property that can fill their pipelines. Big companies are getting out of the R&D business. You see that in pharmaceuticals. The medical device industry is following close behind. In fact, if you've been following the news, and recently Forbes did a survey, they said 80% of the medical device companies that they surveyed said they were looking for outside partnerships as a way to get the devices to fill their pipeline. The reason being is they're just too slow, the market's moving too quick. So this is critical. You don't have to sell a lot. You could just test market it. But you have to prove that it works and that somebody will buy it and document it with research, testimonials, whatever the case is. It doesn't have to be a lot. Of course, if you're selling it, it helps. What you're doing here is you're answering the question, is your device worth the risk? because that's what it comes down to, is the risk. The risk if more development has to go into it, the risk if they have to do work with the FDA, whatever the case is. The other important thing to understand is the medical device industry is moving very quickly. Your technologies are moving very quickly. They don't last anymore. If you get 5 years out of it, you're lucky, because there's so much technology coming in, not only from the United States, but China, other parts of Asia, Central America, Eastern Europe. Medical device technology is a worldwide market, and there's a lot of inventors, a lot of innovation coming into the market very quickly. The second issue that they have is you're giving the wrong information. And generally I find this, the wrong information is that when you go to talk to a company, you go ahead and tell them the life history of how you evolved this technology, where it came from, the amount of money you put into it. You give them your life story. They don't want to hear that. In fact, many companies are reluctant to deal with individual inventors because of all the information that's provided. Oftentimes you disclose information you shouldn't be disclosing to them. What you want to do is you don't want to tell stories. The most important thing that you want to do is solve problems. You are problem solvers. That's what these companies have. They have problems. They have consumers with problems, healthcare problems. They want solutions to them, and that's what they're looking for. So the right information to give them is how your technology solves a problem. At the end of the day, it's show me the money. They want to know that they can make money with your IP, that it's going to address a market need, that it's got the profit margins in it, that's close to getting to the market. You see, the further away from it is the market, the more unknowns there are, the less testing you've done, development you've done, makes it harder, goes back to risk, means lower royalties. The bigger the markets, the more developed it is, the deeper it is into the market, higher royalties. We can discuss royalty rates, but it's important that you keep that in mind. The third issue, and this is a big one, is no due diligence, and you wind up with the wrong partner. I can tell you that the #1 success factor in licensing is the right partner. But if you get somebody a company that approaches you, and I'm not saying that every company is necessarily, that approaches you is necessarily the wrong one, you have to do some due diligence and figure out if they are the right partner. Because you have to remember, when you sign that licensing agreement, especially if you have a patent, you're in for life. To get out from underneath that can be very costly unless it's a situation where you mutually agree that you do want to get out. And believe me, I've seen some big problems with partners. So you must do your due diligence. You've got to check out the company. Can they handle the product? Are they right? More important, when you deal with a company, are you comfortable dealing with the company? Are you having good discussions? In my experience, having dealt with a lot of companies, there's certain signs that you can tell whether or not you're getting along with the company. Are they responding to you on a timely basis, or are they dragging their feet? Are you supposed to receive a proposal that doesn't come from weeks? Do they tell you one thing and does another thing show up? Okay, these are all signs, and that's why it's important to do your due diligence, because you want to find out as much as you can. And by the way, the more you know about that company, the stronger position it's going to give you for negotiating with the company. And the thing to keep in mind when you're looking at companies is one size does not fit all. Many times you'll have companies approach you and say, we want exclusive, exclusive for the world, exclusive for all distribution channels. That's why you have to do your due diligence. There's exclusives and there's exclusives. And the thing about knowing what a company does is what markets are they going to go after. Remember, a licensing agreement is performance-based, and you want to know if somebody is going to get exclusive, they have to earn the right to continue with that exclusive. And that's why you want to make sure that as you deal with a company, you have to understand what their strengths are, what they're going to do, how they're going to do it, and what their market strengths are. So in wrapping it up, let me just summarize this by saying, when's the right time to license? As I mentioned, I took you through some of the challenging areas. The right time to license it is when you've done your test marketing, validated the technology, gotten into the market, getting the testimonials, and you're starting to move on the upswing toward revenues. That's the time when you've taken the bulk of the risk out of your IP and when companies would be more likely to license it. So in summarizing, avoiding the 3 top mistakes is prove that it works, show them the money, and do your due diligence. So that wraps up this part of the presentation. For those of you who are interested, I offer a newsletter. You can sign up at my website. I put it out every week with articles on licensing and strategy, different issues, and keep you posted on the latest in the licensing world. So with that, I'm going to close the presentation, and now Austin and I are going to open it up to questions from you.